बड़ी खबर के साथ करते हैं। एएमयू पर सुप्रीम कोर्ट में फैसला पढ़ना शुरू हो चुका है। दरअसल सुप्रीम कोर्ट में संविधान पीठ इस वक्त अपना फैसला सुना रही है और 7 जजों की पीठ इस वक्त फैसला सुना रही है। तो अलीगढ़ मुस्लिम यूनिवर्सिटी से जुड़ा ये पूरा मामला, जिसको लेकर के सुप्रीम कोर्ट का फैसला सामने आना था, जिसके बाद से आज देखिए फैसले की शुरुआत हो चुकी है, यानी फैसला पढ़ा जा रहा है और ये बताया जा रहा है कि 7 जजों की ये बेंच है, ये पीठ सुनवाई कर रही है।
The founding or bringing into existence of the institution, the possibility of distinguishing the establishment and incorporation of universities arose with the advent of teaching universities. Two kinds of institutions were incorporated as teaching universities. They consisted of institutions which were established and incorporated at the same time, and institutions in which the establishment of the institution predated its incorporation. Universities in the latter category, however, were teaching colleges converted into teaching universities. The establishment and incorporation of these universities was distinct. The instance of conversion of teaching colleges to teaching universities elucidates the distinction between the establishment and incorporation of educational institutions. The word establish, as used in Article 31, cannot and should not be understood in a narrow and legalistic sense. The words used in Clause 1 of Article 30 have to be interpreted in view of the object and purpose of the article and the guarantee and protection it confers. It cannot be argued that a university was established by Parliament merely because the long title and preamble of the statute incorporating the university states that it is an act to establish and incorporate. If such a formalistic interpretation is adopted, fundamental rights will be made subservient to legislative language. The courts must identify the circumstances surrounding the incorporation of the university, including a thorough reading of the statute, including through a reading of the statute, to identify who established the university. Formalism must give way to actuality and to what is real. The right under Article 31 is guaranteed to minorities as defined upon the commencement of the Constitution. A different right-bearing group cannot be identified for institutions established before the adoption of the Constitution. To determine who established the Constitution, the courts must consider the genesis of the educational institution. For this analysis, the courts must trace the origin of the idea for the establishment of the institution. The court must identify who was the brain behind the establishment of the educational institution. Letters, correspondence with other members of the community, or with government or state officials, and resolutions issued could be valid proof for establishing ideation or the impetus to found and establish. The proof of ideation must point towards one member of the minority or a group from the community. The second indicia is the purpose for which the educational institution was established. Though it is not necessary that the educational institution must have been established only for the benefit of a religious or linguistic minority community, it must predominantly be for its benefit. It is not necessary that education must be provided in the language spoken by the minority or in the religion of the minority. The indicia could be proved by a reference to private communications or speeches about the necessity of establishing an educational institution for the community and a recognition of the educational difficulties faced by that community. The third test is tracing the steps taken towards the implementation of the idea. Information on who contributed the funds for its creation, who was responsible for obtaining the land, and whether the land was donated by a member of the minority community or purchased from funds raised by the minority community for this purpose, or donated by a person from some other community, specifically for the establishment of a minority educational institution, are elements that must be considered. Similar questions must be asked of its assets. The next question is whether the administrative structure of the educational institution is an indicia for the establishment of a minority educational institution. We have already held above that an educational institution is a minority educational institution if it is established by a religious or linguistic minority. We have clarified that it is not necessary to prove that administration vests with the minority to prove that it is a minority educational institution, because the very purpose of Article 31 is to grant special rights on administration as a consequence of establishment. To do otherwise would amount to converting the consequence to a precondition. The right to administer is guaranteed to minority educational institutions to enable them to possess sufficient autonomy to model the educational institution according to the educational values that the community wishes to emphasize. It is not necessary that the purpose can only be implemented if persons belonging to the community helm the administrative affairs. This is so particularly because a minority institution may wish to emphasize secular education. The test to be adopted by the court is whether the administrative setup of the education institution affirms the minority character of the institution. If the administrative structure of the educational institution does not reflect its minority character, or when it does not elucidate that the educational institution was established to protect and promote the interests of the minority, it may, however, be reasonably inferred that the purpose was not to establish an educational institution for the benefit of the minority community. We may specifically deal with a scenario of an educational institution established before the commencement of the Constitution. The test of administration should be evaluated in presentile, that is, on the date of the commencement of the Constitution. An institution to be a minority institution must satisfy the criteria of being administered as a minority institution on the date of the commencement of the Constitution and being a minority institution on the date of formation. Even if an educational institution was established by the minority for the purpose of the community, we must assess the impact of any subsequent events that alter the character of the institution before the commencement of the Constitution. The court may, on a holistic reading of the statutory provisions relating to the administrative setup of the educational institution, deduce if the minority character of the purpose of establishment was relinquished upon incorporation. The question is whether the regulatory measures wrest the administrative control from the founders of the institution. This is a question of fact which must be determined on the facts of each case. The court must make that determination upon a comprehensive analysis of the administrative framework, which includes a host of factors such as the representation of the interests of the community in the administrative setup. The above indicia must be proved through the submission of cogent material. Reliance must be placed on primary sources such as office documents, letters and resolutions, or memorandums issued to implement the resolution. Secondary sources must be only used to corroborate the primary sources. The onus to prove that the educational institution was established by a minority is on the claimants. The view taken in Aziz Basha that an educational institution is not established by a minority if it derives its legal character through a statute is overruled. The question of whether AMU is a minority educational institution must be decided based on the principles laid down in this judgment. The papers of this batch of cases shall be placed before the regular bench for deciding whether AMU is a minority educational institution and for the adjudication of the appeal from the decision of the Allahabad High Court in Malay Shukla's case after receiving instructions from the Chief Justice on the administrative side.
आपको बता रहे हैं कि एएमयू के अल्पसंख्यक दर्जे पर फैसला पढ़ना शुरू कर दिया गया है और साथ ही सुप्रीम कोर्ट में अभी भी ये फैसले की कॉपी इस वक्त डीवाई चंद्रचूड़ पढ़ रहे थे। 7 जजों की पीठ इस वक्त इस पूरे मामले को लेकर के सुनवाई कर रही थी, जिसको लेकर ये पूरा मामला जब सुना गया तो 4-3 के बहुमत से ये फैसला सुनाया जा रहा है और बहुमत का जो फैसला है उस फैसले को सबके समक्ष रख रहे हैं डीवाई चंद्रचूड़। तो फिलहाल ये जानकारी आपको दे दें कि अलीगढ़ मुस्लिम यूनिवर्सिटी को लेकर के पूरा मामला था और इसी पर कुल 4 फैसले हैं। सीजेआई बहुमत का फैसला इस वक्त पढ़ रहे हैं। एएमयू को अल्पसंख्यक का दर्जा दिए जाने का विरोध करने वाले एक वकील ने यह भी दावा किया था कि 2019 और 2023 के बीच केंद्र सरकार से उसे 5,000 करोड़ रुपए से अधिक मिले, जो केंद्रीय यूनिवर्सिटी दिल्ली यूनिवर्सिटी को मिले धन से लगभग दुगना है। जबकि अदालत ने 8 दिन तक दलीलें सुनने के बाद 1 फरवरी 2024 को इस मामले में अपना फैसला सुरक्षित रख लिया था। 1 फरवरी को अदालत ने कहा था कि एएमयू अधिनियम में 1981 के संशोधन ने केवल आधे अधूरे मन से काम किया और संस्थान को 1991 से पहले की स्थिति में बहाल नहीं किया। 1981 के संशोधन ने इसे प्रभावी रूप से अल्पसंख्यक दर्जा दिया था और अनुच्छेद 30 के तहत में एक बड़ा दावा और किया गया। सुप्रीम कोर्ट फैसला सुनाने के पहले ही
Article 30 of the Constitution of India, which deals with the right of minorities to set up educational institutions. We have had the benefit of perusing the erudite majority opinion authored by Honorable the Chief Justice Dr. D.Y. Chandrasud. While the said opinion comprehensively addresses each issue with depth and clarity, we have expressed a differing view on the interpretation of certain aspects given the significant constitutional implications involved. Recognizing the weight of these issues, we have chosen to offer our own perspective, though we acknowledge the thoroughness and diligence with which the Honorable Chief Justice has approached this complex matter. Before we lay down the indicia under Article 30 to determine whether an institution has a minority character and ought to be afforded protection, we deem it appropriate to embark on a substantive analysis of the issues involved and will begin by undertaking a comprehensive examination of the multifaceted nature of minority rights both in India and internationally. Then after discussing the international and within India how the minority rights have been developed and established, then I have referred to the constitutional scheme which ultimately led to formation of Article 29 and 30. Then we have explained the statutory scheme of National Commission for Minority Act 1992 and other relevant statutes having any bearing. Thereafter, I have referred to the brief history of AMU and followed by the features of the AMU Act 1920. Of course, for the reasons which I have assigned later on, these provisions we have not interpreted at this stage. We have only highlighted that what was the statutory scheme. Then we have explained the challenge to the constitutionality of the 1951 and 1965 Amendment Acts in the AMU Act of 1920 and the contentions which were raised in Aziz Basha when these amendments came to be challenged. After taking notice of the rival contentions which were raised before the 5-judge bench in Aziz Basha, then we have also briefly culled down the conclusions drawn by this court in Aziz Basha. After that, we have given the history of discordance with Aziz Basha. There we have said, having analyzed Aziz Basha, it is imperative to also take account the decisions proffered by this court in other relevant cases to holistically understand the background of the reference before this court. Then, after referring to the 1972 amendment in the 1920 Act, we have referred to thereupon the first discordant note was struck by a 2-judge bench of this court in Anjuman. That was a case where the court was considering the minority status of an institution established by a society registered under the Society Registration Act 1860. The question raised therein pertained to whether such registration would be determinative against the minority status of this institution. In this regard, then 2 questions were formulated that we have reproduced, and after discussion, we have said that almost 2 decades after the reference in Anjuman came the magnum opus decision of the 11th bench in TMA Pi. In this case, the court was tasked with analyzing the different facets of Article 30. Then question 3A, which was not answered in TMA Pi, is reproduced. Then after giving history that how the Anjuman was also disposed of, we have referred to the contentions raised in the present case on both sides, the appellant side as well as the respondent side. And after that, we have notified the issues which arise for determination. There we have said, thus in our considered opinion, the instant reference based on the question of the test required to be fulfilled by an institution for seeking protection under Article 30 of the Constitution of India can be broken down into following segmented questions of law and fact. The first prefatory issues are, what are the requisite parameters of reference to a larger bench? What matters were intended to be addressed by the larger bench in Anjuman? What are the facets required to be considered by a regular bench of making a reference is made to a larger bench? What are the powers entrusted to the Chief Justice of India in such circumstances? The second question is whether appellant has the locus standi to bring the present challenge. On the constitutional interpretation, the questions which you have formulated are, what are the tests to seek protection under Article 30 of the Constitution? And what is the meaning of the term established in Article 30? Next is, what is the meaning of the term administer in Article 30? Whether AMU satisfy the test of establish and administer and is thus entitled to the protection of Article 30? Whether the Union of India is obligated to defend the AMU Amendment Act 1981? On the prefatory issue of that what are the requisite parameters of reference to a larger bench, I have opined that the issue concerning the power of a regular bench to refer a matter to a larger bench must be examined in light of the order passed in Anjuman, which opined that Aziz Basha required reconsideration by a larger bench and proceeded to refer it to a 7-judge bench. To this end, the respondents have vehemently contended that such a reference was bad in law and should be declared so. In this vein, we have identified two key aspects of the issue. One, what are the issues identified in Anjuman which are intended for the larger bench to address, and two, whether the manner of making such a reference was legally sound. On the first part, we have said it is crucial to determine whether the bench in Anjuman intended to restrict the reference in such a way that the 7-judge bench would only analyze the criteria necessary for an institution to qualify as a minority institution under Article 30 of the Constitution. For the sake of clarity and despite the risk of repetition, we find it essential to put forth the relevant aspect. Then again, we have reproduced the reference order and then explained a plain reading of these observations revealed that the 2-judge bench in Anjuman doubted the correctness of the decision Aziz Basha and the principles enunciated therein. The bench, while questioning the holding of Aziz Basha, also borrowed strength from the views expressed by some jurists. In Aziz Basha, the issue pertained to the constitutional validity of AMU 1951 and 1965 Amendment Act. While questioning the correctness of the decision Aziz Basha, it is evident that the reference in Anjuman also insinuated that potential errors may have occurred in the analysis of the constitutionality of those enactments. The reference seeking to reopen the issues settled in Aziz Basha thus necessarily mean not only to re-examine the correctness of that decision, but also an attempt to revisit the constitutionality of the AMU 1951 and 1965 Amendment Acts. Importantly, the key term used in the reference order in Anjuman is "and," which is clearly used to state that both Aziz Basha's case may also be considered, and second, the ingredients of a minority institution should be examined definitively. Such an analysis would also have to consider the question posed in TMA Pi under 3 sub A regarding the criteria required for an institution to qualify as a minority institution under Article 30 of the Constitution, and consequently as to whether AMU fulfills such criteria or not. We therefore find it difficult to align ourselves with the opinion expressed by the majority led by Honorable Chief Justice, according to which the reference before us was limited to determining only the criteria an educational institution must meet under Article 30 of the Constitution. However, given the Honorable Chief Justice's decision to further refer the matter pertaining to AMU to a regular bench, we have confined our views to discerning the relevant indicia under Article 30 so as to avoid binding or influencing the regular bench that will ultimately decide the factual issue. Then on the question of manner of making reference to a larger bench, we have said the 2-judge bench in Anjuman, after expressing doubt about the correctness of Aziz Basha and its principles, referred the matter for reconsideration to a larger bench. Additionally, the bench in Anjuman specifically stated that the larger bench reviewing Aziz Basha decision by a 5-judge bench should consist of 7 judges. The decision further directed that the matter be placed before Honorable Chief Justice for appropriate directions. Such a reference, to our mind, is not consistent with the established norms of judicial propriety. There are several reasons which substantiate this school of thought. For instance, Order 7 Rule 2 of the Supreme Court Rules 1966 as applicable during the time of the reference was made. We have reproduced the rule. In this regard, it is imperative to refer to the findings of the Constitutional Bench in Central Board of Daud Bohra Community, that subsequent Constitutional Bench, which while adjudicating the correctness of previous decision on the Bombay Prevention of Excommunication Act also laid down pertinent principles on the procedure of making references. The decision in Daud Bohra essentially clarified the framework concerning how a reference should be made, particularly when a bench of lesser strength doubts the correctness of a decision by a larger bench or co-equal bench. After referring to Daud Bohra, we have said the principles enunciated in Daud Bohra reinforce the provisions of the Supreme Court rules referred to earlier and also reiterate the well-established principles based upon doctrines of predictability, consistency, finality, and the principle of stare decisis. The 2-judge bench in Anjuman ought to have understood and applied the law consistent with these principles. The 2-judge bench in Anjuman, being of lesser strength than the 5-judge bench in Aziz Basha, lacked the authority to explicitly question the correctness of Aziz Basha and refer the matter to a 7-judge bench. In Anjuman, the bench not only referred the matter but also specified the numerical strength of the bench to which it should be referred, with a further direction that the matter be placed before the Chief Justice for the limited purpose of notifying the composition of the 7-judge bench. With utmost respect at our command, we do not appreciate as to how a 2-judge bench could dictate its viewpoint to the Chief Justice of India. Thus, to our mind, effectively impaired the Chief Justice authority as the master of the roster. Allowing such a practice would enable benches of lesser strength, such as a 2-judge bench, to undermine the decision of larger benches, potentially even as 11-judge bench. This would also place the Chief Justice of India in an untenable position which would be bound by a judicial order who will be bound by a judicial order which, while acting in an administrative role, leading to procedural complications and embarrassment. We reiterate that such action completely undermines the principles of stare decisis, a well-established doctrine that mandates the consistent application of legal principles once pronounced by authoritative courts. This principle is rooted in the idea that once a court has determined a rule applicable to a specific set of circumstances, it should be followed in all future cases. After that, we have explained the principles which govern this issue, and we concluded we thus have no hesitation in holding that it is the Chief Justice of India alone who is the custodian of the authority to determine the composition of benches and the public or national interest, place a matter before any bench he deems appropriate, even in the absence of any reference. That being so, now we have said that 2019 reference order, which was by a three-judge bench, which included the then Chief Justice of India, cannot be faulted. Consequently, based on that order, we consider it appropriate to proceed with the determination of some of the issues concerning the constitutional challenge. We also respectfully disagree with the majority opinion authored by Honorable Chief Justice in paragraph 39 of his draft judgment, according to which Anjuman has merely doubted and not disagreed with Aziz Basha. It seems to us that the term doubt and disagree broadly carry similar connotations. It is difficult to doubt a judicial opinion unless we disagree with the correctness of the contents and substance. Similarly, a disagreement would originate only when such opinion is shrouded with doubts on law or on facts. Then, after explaining these principles, of course, as we have said that the 2019 reference was maintainable because that was a bench presided by Honorable Chief Justice. In conclusion, while fundamental rights cannot be applied, now before that, we have explained the locus of the pre-constitutional institution, that we have held that appellant is entitled to, the pre-constitutional institutions are also entitled to seek protection of Article 30. The conclusion drawn in this regard is, in conclusion, while fundamental rights cannot be applied retrospectively to disrupt pre-constitutional practices, the appellant is not barred from asserting a claim under Article 30 as long as the necessary conditions of this provision are met. Individuals or institutions who qualify to be protected through a fundamental right as of 26 January 1950 are entitled to enforce these